Hello, everybody, and welcome back to the most recent episode of SEC Roundup. I'm Nick Morgan, and I'm joined, as always, by my fellow board member, Tom Zucchero. Tom, how are you doing?
I'm doing well, Nick. How are you?
I'm doing well, thanks. And our special guest today is Jennifer Hahn, who is the Executive Vice President, Chief Counsel, and Head of Regulatory Affairs at the Managed Funds Association, MFA. Jen, thank you for joining us.
Great. Thanks for having me.
So we're revisiting a topic we talked about in an episode last year, although with a slightly different focus. So we had talked about the SEC's enforcement actions around a topic called ephemeral messaging. Those cases that Tom's going to talk about a little bit had to do with broker-dealers. The reason we're revisiting it and asked Jen to join us today is because the MFA and a group of others submitted a letter to the SEC questioning the SEC's actions in this area with regard to investment advisors specifically. And we took particular note of the letter because of the lineup of signatories on the letter. I mean, in addition to the MFA, there was SIFMA, SIFMA AMG, National Venture Capital Association, American Investment Council, Chamber, Investment Company Institute, Association for Corporate Growth, Small Business Investor Alliance. So it's quite the lineup, and raised some very interesting issues. So we appreciate Jen joining us today to talk about that. But before we turn and get comments from Jen, Tom, can you remind us, how did this issue start to come up in recent times, and how has the focus shifted from the SEC?
Yeah, thanks, Nick. So we'll call it off-channel messaging, and this is one of the most recent SEC enforcement fascinations. Where they are, these enforcement staff is focused on employees of broker-dealers, and in one case, an investment advisor, who communicate through non-firm authorized apps, such as WhatsApp or Signal or other, again, unauthorized or non-firm communication applications. And the staff's concern, particularly with respect to broker-dealers, is that the firm is not keeping track of these communications and therefore not complying with their record-keeping obligations as broker-dealers. And in some cases, the apps are ephemeral, which means the messages disappear after a period of time, sometimes a short period of time. So it motivated the commission was a concern, again, that the firm's failure to monitor and preserve these communications violates their record-keeping obligations. There was a case brought in 2021 with a $200 million penalty. And then last September, the CFTC and the SEC brought a series of 15 actions totaling $1.8 billion in penalties. And the reason why we're discussing it today, and the reason why Jan has joined us, is that the last enforcement action involved an investment advisor. And I think Jan can fill us in on her view on whether these rules or these enforcement actions should apply to investment advisors who are regulated by a totally different set of rules than broker-dealers. So with that, Jen, I hand it to you.
Sure. So the reason we decided to send in a letter to the SEC was really, I think very broadly, it's become known, within the industry that the SEC is conducting an enforcement sweep of investment advisors. And what we are picking up is that they are very much treating investment advisors as if they were under or subject to the same requirements as broker-dealers. And so we thought it was very important to highlight that investment advisors are subject to a different regime. And so under the Advisors Act, you have two rules which are relevant in cases like this. And so one is the record-keeping rule and one is the compliance rule. We thought it was really important to indicate that advisors under the record-keeping rule are not required to keep all electronic communications as broker-dealers are. And so I think that is a very clear distinction right there. The other point we wanted to raise with respect to how the SEC interprets the compliance rule. As is practice, a lot of advisors may have policies which go above and beyond strict regulatory requirements. And this is generally seen as a good thing to give themselves a buffer and to use judgment. But to the extent that the SEC is considering any exception to an internal policies and procedures as a violation of their compliance rule, we think that's problematic, as you are discouraging some of the practices which are really meant to enhance internal practices. And so these are the things we really wanted to highlight to make sure that as they look at advisor record keeping, they understand that it is subject to a different regulatory regime, that subjecting them to the extent there are enforcement cases here really is a violation of the Administrative Procedures Act, in that they would be engaging in rulemaking through enforcement. I think you're all very familiar that when you have one market participant, one registrant, and they're faced with a fine or fighting it in court, it just makes a lot more practical sense to settle a case. But a lot of times, as attorneys are advising their clients, it really sets precedent. So we really wanted to clarify what the rules are. And so our letter focuses very much on the regulatory requirements. And also, I think the SEC itself has recognized this, because in 2011, the staff said, look, maybe we consider amending the Advisors Act, the Advisors Regulation. But right now, they do not require all written communications to be maintained.
I thought it was interesting, Jen, that in your letter to the SEC, you pointed out that the study that you're alluding to that the SEC had done in-house years ago, and that they, in following that study, had not sought to amend the statutory authorization here. So one of the arguments you made was that this activity could exceed the SEC's statutory authority, which, of course, Tom and I have seen the SEC do in other contexts. And that study also highlighted the potential cost that this could impose ultimately on investors who are seeking out the services of investment advisors. So thank you very much for your time today, and we appreciate your letter. We'll include a link to your letter when this video is posted. We really appreciate you coming on and talking with us.
Great. Thank you.
Thanks, Jen.
Thank
All
you.
right. Well, and to everybody else, we'll see you next time on the next SEC Roundup. Until then, goodbye.